Leading Case 20. Technip SA v. SMS Holding Limited and Ors. 1 Supple. SCR 223-5 SCC 465. In this leading case analysis, we delve into the significant legal outcomes of Technip SA v. SMS Holding Limited and Ors, a landmark case that has shaped the landscape of international arbitration and commercial law. This case study is essential for law firms, businesses, and individuals seeking to understand the importance of jurisdiction issues, contract disputes, and investor protection in international business transactions. The court decision in this case has set a crucial legal precedent, offering valuable insights into litigation strategies, dispute resolution, and the protection of legal rights. Join us as we explore the complexities of arbitration law and the impact of this case on the business community. Hi, I am Advocate Dr. Saurabh Kapoor, bringing you a video on this fascinating topic like this. But before you start watching this video, I request you to kindly like, subscribe, and hit the bell icon to my YouTube channel to view videos like this more. Please leave a comment below telling your thought and idea about this video and future videos you want. Kindly share this video with your friends, family, and social groups to spread this knowledge. Technip SA v. SMS Holding Limited and Ors is a significant case decided by the Supreme Court of India in 2005. The case dealt with the issue of whether Indian courts had jurisdiction to entertain a dispute arising out of a contract between two foreign parties, where the contract provided for arbitration in a foreign country. The case involved a contract between Technip SA, a French company, and SMS Holding Limited, a Pakistani company, for the construction of a petrochemical complex in Pakistan. The contract provided for arbitration in Geneva, Switzerland, in case of any dispute. The dispute arose when Technip SA terminated the contract and initiated arbitration proceedings in Geneva. SMS Holding Limited challenged the termination of the contract in the High Court of Delhi and argued that Indian courts had jurisdiction to entertain the dispute, despite the arbitration clause in the contract. The Supreme Court held that Indian courts did have jurisdiction to entertain the dispute, as the contract had a significant connection with India. The court held that the mere fact that the arbitration was to be held in a foreign country did not deprive Indian courts of their jurisdiction to decide the dispute. The court further held that the arbitration clause in the contract did not exclude the jurisdiction of Indian courts, and that the parties could approach Indian courts for interim relief in appropriate cases. The judgment in the Technip SA case has had significant implications for international commercial arbitration in India. It has established the principle that Indian courts have jurisdiction to entertain disputes arising out of contracts with a significant connection to India, even if the contract provides for arbitration in a foreign country. The judgment has also clarified the relationship between Indian courts and international arbitration, and the circumstances under which Indian courts can intervene in international arbitration proceedings. Facts. In this case, an appeal has been filed before the Supreme Court of India. The appellant, Technip SA Company Incorporated in France, and the respondents are the shareholders of Southeast Asia Marine Engineering and Construction Limited, a company incorporated/registered in India and a subsidiary of Coflexip, which controls the majority shareholding of the company through a chain of wholly owned subsidiaries. The appeal involves two other parties as well, which are the Institut Français du Pétrole and ISIS. ISIS is IFP's subsidiary, through which IFP is a shareholder in Technip and Coflexip. Technip had acquired control of SEAMEC through Coflexip, and as per the Securities and Exchange Board of India Regulations, 1997, Technip, consequent of change of control of SEAMEC, would be bound to offer to purchase the shares of the minority shareholders in SEAMEC. Concerning certain issues, some shareholders of SEAMEC filed a complaint against Technip before the Securities and Exchange Board of India under the SEBI Act, 1992. It was held that French law applied to the takeover in question. Thus, Technip had obtained control of Coflexip in July 2001. Additionally, Technip had acquired 58.4% of the shares/voting rights and control in SEAMEC in July 2001 without making a public offer. In doing so, there was a violation of Regulations 10 and 12 of the SEBI regulations. SEBI took July 3, 2001 as the specified date for calculation of the offered price and directed Technip to pay interest at the rate of 15% per annum to the minority shareholders of SEAMEC for the delayed public announcement, who as a consequence preferred an appeal before Securities Appellate Tribunal. SAT held that Indian law was applicable and the relevant date of control was 12th of April, 2000, not July 2001. SAT, therefore, directed Technip to pay SEAMEC shareholders the difference between the price of the shares between July 2001 and April 2000, together with a 15% rate of interest on such difference. The appellant has, thus, approached the Supreme Court of India now. 2. Issues. The issues in the present case were primarily about the following. The maintainability of the present appeal. If the applicable law would be French law wherein the appellants were incorporated, or Indian law, i.e., where the respondent is incorporated/registered. Whether the appellant acquired control of the respondent through Coflexip in April 2000 or in July 2001. The rate of interest of 15%, the adjustment of dividend, and the identification of the shareholders. 3. Reasoning of the court. The Honorable Court observes Section 15Z of the SEBI Act, 1992, which provides for an aggrieved to file an appeal on any question of law arising out of an order of the SAT. As per the Supreme Court, the dispute regarding the application of either French law or Indian law to the transaction is undoubtedly a question of law. Furthermore, referencing precedents, the court observed that issues relating to internal affairs of companies are to be resolved by applying the law of their domicile. However, SEBI concluded that Indian law would apply over Technip acquiring control over Coflexip despite both the companies being domiciled in France. The court thus opined that questioning of this won't be a question of fact. The court, after analyzing sections 355-1 and 356-1 of the French Companies Act, 1966, determined that French law could not be conceived as violative of public policy underlying the SEBI Act and regulation, as the difference only lay regarding the prescribed limit of shareholding for control by one company over another. Thus, the law could not be disregarded. For which reason the court held that French law must be applied to decide when Technip took control of Coflexip. The court opined that for the appellant to have violated regulations 10 to 12, it would have to be established by the respondent that the purchase of shares by Technip in Coflexip was done to assume control over SEAMEC. Furthermore, to determine whether Technip took control of Coflexip in April 2000 or July 2001 as contended by the respondent and appellant respectively, the Supreme Court observed the definitions of acquirer, control, acting in concert, and target company, provided under the SEBI regulations, the Bhagwati Committee report, and Note 7 to Rule 9.1 of the City Code on Takeovers and Mergers, since it had to be proved that Technip acquired or agreed to acquire the right to control SEAMEC either by itself or acting in concert with ISIS. The proof required to establish such a concert is one of probability. For the aforementioned, the Supreme Court considered the facts of the instant case. As per the facts, in April 2000, the board of Technip approved a deal with a shareholder of Coflexip to purchase 29.68% shares and thereafter complied with the requirements of Article 356-1. However, only in October 2001 Technip acquired control of 99.04% of ISIS's share capital and thus 98.36% of Coflexip's share capital. Further, Coflexip's shares were registered in the name of Technip on October 19, 2001. Additionally, the special committee which was set up vis-à-vis Technip's offer to purchase balance shares of Coflexip on July 3, 2001, of which ISIS was a part, recommended for the payment of a higher price than Technip had offered originally. Considering all these facts along with standard laws, the court concluded that with regards to the balance of probabilities there was no evidence to prove control of Coflexip in April 2000. And the concert was a strategic alliance. A simple fact that 2 annual general meetings of Coflexip involved Technip in the majority wasn't enough to establish control over Coflexip. 4. Judgment. The Supreme Court, considering the aforementioned rationale, observed that the allegation of ISIS and Technip acting in consensus in the purchase of 29.68% shares in Coflexip had not been established presently. Furthermore, there was no evidence that Technip acquired Coflexip in April 2000 to gain control of SEAMEC. Therefore, it was held that SEBI's order would prevail and the order of SAT was consequently set aside. As far as the remaining issues pertaining to the rate of interest, the adjustment of dividend, and the identification of the shareholders of SEAMEC, the same would arise only if SAT's order had been upheld. Lastly, the court stated that the appeals for the bank guarantees furnished by Technip to secure the difference in amounts between the share prices which would be otherwise payable by Technip were held to be discharged. V. Comment. In the instant case, the main object for consideration was pertaining to the question law applicable and when the appellant had assumed control over Coflexip to ascertain the amount payable to the shareholders. Considering the case of Aberdeen Asia Pacific including Japan Equity Fund v. Sit, the Bombay High Court had held that the status of an entity incorporated abroad has to be determined even in India according to the law of the country where the entity was incorporated. Thus, the Supreme Court in the present case, observing the French Commercial Law and Companies Act, has rightly observed that the status of a corporation, being an artificial legal entity, must be determined subject to the exception of grave domestic public policy violation with regards to the basic principles of morality and justice, in accordance with the laws of the country of its domicile/incorporation. since the laws of France are not in gross breach of public policy of Indian law, since a simple distinction or contradiction between the Indian law cannot be termed as so, since that would defeat the fundamental purpose of private international law. Thus, the law applicable undoubtedly has to be the French law as determined by SEBI. Furthermore, as per the facts of the case, the respondents contended that the appellant was in concert with the shareholder of Coflexip. However, considering the same, it is evident that ISIS was not interested in acquiring any more shares in Coflexip. Also, it did have the financial means to do so. Both IFP and ISIS were government-controlled, which means that ISIS not exercising its preemptive right under the shareholders' agreement has a plausible explanation. Lastly, IFP, considering the facts of the case, did not have the policy to manage the company it happened to invest in. In the instant case, SAT and SEBI had held that Technip had violated regulations 10 to 12 of the SEBI regulations. However, to do the same, it would have to be established that the purchase of shares by the appellant in Coflexip was implemented for control over SEAMEC, which the respondents failed to prove as well. Thus, the appellants cannot be held liable under that either. Furthermore, the SEBI observed that with regards to regulations 10 to 12, SEAMEC formed a small and insignificant portion of the total business of Coflexip, contributing merely 2% of the total asset base of Coflexip as on December 2000. This finding was not disregarded or reversed by the SAT either. Therefore, mere observation concerning SEAMEC's assets is not enough to prove that Technip purchased Stina's share in Coflexip for SEAMEC. Thus, this case examined the facts primarily concerning a question of law and went for a compendious interpretation of the facts and applicable case laws and statutes, thereby ascertaining when the transaction in question happened in actuality. The major highlight of the case is how foreign laws can be determined in Indian case and when they cause a gross breach of public policy, and that its interpretation has to be narrow. Vi. Conclusion. As provided by the judgment in the present case, to resolve a particular conflict, a court has to examine the text of the French law and, along with the material on record, has to determine the appropriate application of the said provisions. The court's judgment in this case and the rationale followed have been furthered in several other cases involving similar questions of law. The Supreme Court, thus, in the landmark case of Technip SA, SMS Holding Limited and Ours, has rightly upheld the judgment of SEBI and provided for the application of foreign law of a company's domicile in India after examining several foreign provisions and case laws along with the Bhagwati Committee report of 1997. Did you know that the Technip SA SMS Holding case set significant precedents in international arbitration, influencing how disputes are resolved across borders? Today, we're going to explore one of the leading cases in contract law, which has far-reaching implications for international business agreements. This case is Technip SA SMS Holding Private Limited and Ours, and it's a landmark judgment that has shaped the way businesses operate globally. The significance of this case lies in its ability to set a new standard for resolving disputes in international contracts. It's a case that has been widely cited and has influenced the development of international arbitration law. So, let's dive into the details of this case and explore what made it so important. In essence, the Technip SA SMS Holding case is a testament to the complexities of international business agreements and the need for effective dispute resolution mechanisms. As we delve deeper into this case, we'll explore the legal implications and the impact it has had on the business world. Technip SA, a leading engineering company, had a significant presence in the global energy sector. On the other hand, SMS Holding Private Limited was a Pakistani company operating in the same sector. At first glance, it seemed like a routine business deal between two companies, but little did they know that their agreement would become a landmark case in contract law. Technip SA was known for its expertise in engineering, procurement, and construction projects. The company had a strong reputation for delivering complex projects on time and within budget. SMS Holding, on the other hand, was a relatively smaller company with operations in Pakistan. The two companies entered into a contract for a project in Pakistan, which seemed like a routine business agreement. However, things took a turn for the worse when disputes arose regarding the terms of the contract. The contractual disputes eventually led to a legal battle that would change the landscape of international arbitration. The events leading up to the case were complex and involved a series of miscommunications and misunderstandings between the two parties. Technip SA and SMS Holding had different interpretations of the contract, which ultimately led to a dispute over the scope of work and payment terms. The contractual disputes escalated, and both parties decided to seek legal recourse. Technip SA filed a claim against SMS Holding, alleging that the Pakistani company had breached the terms of the contract. SMS Holding, on the other hand, countered that Technip SA had failed to fulfill its obligations under the agreement. The legal battle was intense, with both sides presenting their arguments in court. Technip SA argued that the contract was governed by French law, while SMS Holding claimed that Pakistani law applied. The court had to navigate the complexities of international contract law to determine which law was applicable. The jurisdictional issue was a major hurdle in the case. Technip SA argued that the contract was subject to the jurisdiction of the French courts, while SMS Holding insisted that the Pakistani courts had jurisdiction. The court ultimately had to decide which court had jurisdiction over the dispute. Technip SA also faced challenges in enforcing the contract. The company had to navigate the complexities of international arbitration law to ensure that the contract was enforceable in Pakistan. The differing legal standards between France and Pakistan added an extra layer of complexity to the case. The court's decision was eagerly awaited by both parties. The judgment would not only resolve the dispute between Technip SA and SMS Holding but also set a precedent for future international contracts. The court ultimately ruled in favor of Technip SA, holding that the contract was governed by French law. The court's decision was based on a thorough analysis of the contract and the applicable law. The judgment provided clarity on the jurisdictional issues in the enforcement of international contracts. The implications of the judgment were far-reaching, and it has since been cited in numerous international arbitration cases. The Technip SA v. SMS Holding case has had a significant impact on international business agreements. The case highlights the importance of clear and concise contract drafting, as well as the need for effective dispute resolution mechanisms. It also emphasizes the importance of understanding the applicable law and jurisdiction in international contracts. In summary, the Technip SA v. SMS Holding case is a landmark judgment that has shaped the way businesses operate globally. The case highlights the complexities of international contract law and the need for effective dispute resolution mechanisms. It's a must-know for anyone involved in international business agreements. If you're interested in learning more about international contract law, I encourage you to explore further. There are many more cases like Technip SA v. SMS Holding that have shaped the legal landscape of international business. Be sure to check out our other videos on similar legal cases or topics for further learning.